The petitioner's second witness, Dr. Michael Kwesa-White, testified in court on Tuesday. His witness statement was taken into evidence, after which he was subjected to questions from the Electoral Commission's counsel and lawyers for President Akufo-Addo. The cross-examination mainly centered on issues relating to whether or not the EC chairperson did indeed instruct that he goes over and confers with the party's presidential candidate. Beyond those questions from the lawyers, the bench also had some questions to ask. Here is a bit of the interactions between the lawyers and the bench and the witness as well.
You were not present at the commission because you left when you realized that the petitioner had lost the election.
My Lord, that cannot be true, because as at the time we were instructed to go and have deliberations with the petitioner in that room, we had come nowhere close to knowing who had won and who had lost, because the totals as they were coming from the regions had not been put together, and of course there were issues with some of them. So we couldn't have even put the totals together and decided that candidate A or B had won the election. So there is no reason why anybody should believe that we had left because we noticed that A or B was losing the election. Besides, we did not go into that room with a fixated mindset that by all means our candidate must win.
As a lecturer, I believe that when you deliver an official process, you ought to be receipted for. Is that correct?
That is correct, my Lord.
Now look at your document and tell us where it is indicated that it was received at the headquarters or any other branch of the first respondent. Indicate for me.
My Lord, there is no indication of it on the letter.
I am further putting it to you that this letter was generated by you in order that you will hide your failings as an agent of the petitioner in the strong room.
That's not correct, my Lord.
But then, seriously speaking, you did not take your training seriously. No, please.
It's not an appropriate question.
I want to be clear. You've gone to do a particular job. Then, instead of doing the particular job that sent you there, you take instructions from somebody else. Then you leave your job. You see, that's what I want to find out. Then you did not help the petitioner.
My Lord, with respect, His Lordship is entitled to his opinion about what the petitioner did. In terms of factual evidence about what he did and the reasons that he has answered. He has, in terms of, His Lordship can have his opinion. That's his opinion to have, and he can have it as well. But in terms of what the petitioner did and why he did it, he has answered the question. So I don't think he can be harassed with these opinions.
Please, I take deference to that. I am not harassing the witness. It's not my duty to harass him. Well, I know that he has been sent by the petitioner to do a job for him. Then somebody tells you, oh, go to the petitioner and consult him. If the petitioner could do the work, he himself would have been there. That's what I want to find out. But
as far as lawyers for Mr. Mahama are concerned, and the legal team for that matter, they indicate that they are satisfied with the processes so far.
The evidence of Dr. Kwesa-White made it abundantly clear that the chairperson of the Electoral Commission on that very day acted in bad faith.
President Akufo-Addo's legal team, however, disagrees.
We are beginning to see clearly that fallacy, at best, is something that cannot stand cross-examination.
The case is back in court on Wednesday, and the main business of the day will be the issues relating to the request that is being made of the Electoral Commission to allow for some documents to be inspected, and the arguments will be taken from the various legal teams related to that particular issue. Reporting for JoyNews from the Supreme Court, my name is Joseph Akable.
The court is indeed back later this morning, but let's talk about what happened yesterday. Lots of you are interested in knowing after the press conference, the two sides both said it was a good day for them in court. That's what they always say. But let's put some of the issues under proper scrutiny. My guests from yesterday are back. Dr. Poku Edusei is a lawyer and a member of the NPP communications team. We'll have Justice Abdullahi, who is law lecturer at the UPSA School of Law, also joining us. And then Kojoga Adaudu, a member of the NDC's legal team and a lawyer himself, will also be joining us. But first, let's begin the conversation with Dr. Poku Edusei, member of the NPP communications team. A very good morning to you. Thank you so much for making time again today.
Good morning, Amani, and good morning to your listeners and viewers.
Okay.
We're out of the outskirts of Accra, so if the network is bad, then that could be the cause.
Okay, all right, appreciate that. But let's look at yesterday. Would you say that the team managed to get from the second witness through the cross-examination what you wanted to achieve? Okay, so I guess we're beginning to have the challenges that he talked about. Dr. Poku Edusei, can you hear me? Otherwise, we would have to raise him on the telephone line since the connection on the Zoom is not doing us any good. So Dr. Poku Edusei, a member of the NPP communications team, will be joining us. We'll have Justice Abdullahi, he's a law lecturer, and then we'll have Kojoga Adaudu. We'll go through the process yesterday, and then we'll look ahead to today. There's an issue of cross-checking documents presented by the first respondent, the Electoral Commission. We will see how the courts will deal with that matter this morning. And as they have indicated, if there is enough time, then they will jump into asking another witness. And this is a very important witness, Jean Mensah, the returning officer in the presidential elections, and also the chairperson of the Electoral Commission. Let's go back and speak to Dr. Poku Edusei. Doc, if you can hear me. Can you hear me now? Let's see if this is better.
I guess so.
Okay, great.
I hope you can.
Yes, I can hear you. So I wanted to know if the team achieved the purpose for the cross-examination yesterday.
Well, you know, what I said yesterday was that we have, and that strategy is to study the witness statement of the witness, in this case, Dr. Michael Pesa-White, and check whether what he has put out as his evidence in chief contributing significantly to the petition. When we perused through the entire document, we realized that he wasn't meaningfully contributing to the case of the petitioner. And it was because
I'm afraid
he was basically in what-off. So we decided to, I don't know if you can hear me.
I can hear you now. There was a little break, but we're back on track.
Yeah, so when he finished with the lawyers of EC, finished with him, we realized that for the case that is in court, he wasn't meaningfully contributing to it. So we decided not to allow him to put in a lot of evidence that they had prepped him on. You know, when Mr. Sedun Katia, who was more or less the star witness, the CEO for NDC and the coordinator of the national elections testified, we realized that he was given a lot of figures. And when he was asked the crucial questions, what were the calculated figures, said it eloquent, being able.
Well, I'm afraid we we cannot continue with the Zoom. If my producers can kindly call Dr. Poku to say, let's deal with the phone. There's too many breaks in that Zoom connection, obviously because of the network from where he is. So we're going to raise Dr. Poku to say back, hopefully on the telephone line, so we can have a good conversation. Dr. Poku to say, apologies, we have to change course and do phone. The breaks are, too many, I guess. So let's have a fruitful conversation via phone. If you can continue.
Yes, what I was saying was that when Mr. Stephen Ketia testified, there were a lot of gaps that he left in his testimony, and he wasn't going to help the case of the petitioner. So the second witness thought you could get the opportunity to fill in those gaps. And I'm telling you, they had armed him with the requisite information to put it in. And we also had a strategy that will not allow you to feed in that kind of information by asking a lot of elaborate questions. So we limited ourselves to the issue of the so-called instruction, the word instructed to, and asked whether he had a personal engagement with the chair of the EC. And the answer was that he never had any personal engagement with the chair of the EC. So if you have not interacted personally with a person, how would you be able to take instruction from that person? Then it turned out that, the instructions came through my colleague, Mr. Rojo Metonunu. So it tells you it wasn't a gunman situation as he, on the witness stand, sought to portray, in that sense that he wasn't commanded because there was no personal engagement between Pesa White and Madam Jane Mensah. For that reason, there couldn't have been that kind of instruction. So we were very snappy, we were brief, and made sure that they were not able to fill in the gaps.
So are you by that saying that a person cannot be instructed through another to do something?
When in his witness statement he used the word asked, right? He was asked. And actually that is the evidence he has led in. So in this case, he was even contradicting himself. But on the witness stand, he started using a different word, instructed to. That is a form of command. It's different from when you are being requested or asked, which is more or less like not mandatory, but instructed to becomes a command against you to do. In this case, if you have not had one-on-one engagement and you are taking your narrative from some other person, you won't be able to portray it as a gunman situation as he sought to do. As if he had a gun on his head that if you don't go, you will suffer some form of sanction. And it turned out that he was never in personal interaction with the chair of the EC. And for that reason, his use of the word instructed will not be able to hold sway, and will address the court on that.
Okay. So there are about 20 minutes, and I was checking the time. The 20 minutes that you got in cross-examining the witness, you think that in the end, you got the useful points that you wanted to make, you achieved it, and so you let him go. Let me ask Kojoga Dawudu, who's also joined us. Let me say good morning to you, first of all, if you can hear me.
Yeah, good morning, Mama V, and good morning to your cherished listeners. Okay. And good morning to Dr. Edus Poku.
All right, great.
Yeah, good morning.
Kojoga Dawudu, it wasn't such a great time for your witness in court. I mean, if you look at the commentary coming following his testimony, it's not so good, is it?
It was a great time. It was a great time for us. And where they are dwelling on is that where he was using asked and instructed interchangeably, which he had said, and he told the court that he was using those two interchangeably. But let me come to, where they think that he was not there personally or did not have an interface or encounter personally with the returning officer or the chairperson of the commission. They went to, they were accredited. So in law, yes, they have been accredited. They were working as a team. And when there were issues of the irregularities, evidence that things were not going on well, that was when, if they don't know the content of the thing, then discuss it with the flag bearer. I think it is on this that when he was informed that this is what was the result of our engagement or the conversation we had. So we have to go and see the flag bearer or the former president. So I don't see that he hasn't had interface with the returning officer. Does not mean that there was no conversation, there was no message that was given that they had to leave to go and see the flag bearer. And people are saying that he said, yes, they've been deceived because they acted in good faith because of what they have heard from her after the engagement, and they left. Now, let me give a classical example to buttress the point that he is saying that they have been deceived. And under no circumstances, a person of Dr. Kwesa White's caliber or Rojo Metilnunu's caliber, for all they have done and the experience they have in electoral matters, will just spew lies or say things that spew falsehood, right? Let me give you a classical example about one of the conduct of the Electoral Commission, which will buttress that, yes, this has been said, and they did the other way around. When they said the people of Hohwe, and the court also decided that Hohwe constituency would only come to an end in 2021, and they were under Hohwe and could vote. Yes, the Electoral Commission gave assurance that they will allow them to vote. What did we see? It was on the 6th of December that they sent a letter that they cannot vote in the parliamentary. Well, have they not been deceived?
Well, Mr. Dawodu, great example.
Yes, they were deceived.
I was just going to say great example, but in the matter that we're talking about, I'm not sure that this example would matter. But I want to ask you, was it deceit that you wanted to establish through the witness you put on the stands yesterday?
No, I think we were establishing the bad faith. And we were also establishing that they were there to conduct due process. The issue where it's been said that our agents signed from the polling station to the constituency to the regional collation, it has been signed. So the fact that the agents have signed, it means that when it comes to the National Collation Center, you cannot do due process. You cannot do due diligence. That means that the summation, even if it is wrong, it should be accepted. And we are saying that that is not the process. The fact that they have signed, when it comes to the National Collation Center, you need to go through the figures. You need to make sure it's the same figures. Make sure to see that those figures, the addition, the summation, it's right. When the summation is not right, although it's been signed and the summation and others are not right, you are entitled to raise issues. And we are saying that those are some of the processes that did not go on.
Okay.
So the processes leading to a declaration.
Also revealed through your witness, Mr. Dawodu. Mr. Dawodu, if you can hear me, I was just trying to make the points that your witness also disclosed that there was a portion that was not signed by those on the ground at the regional level, but one of the agents did sign in error. And we're talking due process. That's why I brought that in. But quickly, I want to get Mr. Poku Duse into this conversation. Mr. Duse, how much of the lessons learned in the 2012 petition is playing out in this one that you probably may feel that the other side didn't learn those lessons?
Well, we got a precedent in 2013 that elections are won at the polling station. So in this case, I will venture to add that they are actually processes that happen at polling stations, constituency collation offices, and regional collation centers, which is where the real deal is. So an agent on the ground, in this case at the regional level, Mr. Brojajev, who you have trained and have signed on for Ashanti region, there is no way that the people who have done the primary work at the polling station level, at the constituency, and then at the regional level, you at the national level will have superior knowledge over them. So when they sign and they give you the figures at the national level and they count, your decision whether to sign or not is immaterial. Because the real action as to where the primary data occurred is from the base.
Yeah, but if it is immaterial, then why do you have agents at the national level?
Exactly.
Yes, just to cross-check. But in this case, in cross-checking, you can only have a reason to indicate that I am refusing to sign because the numbers that have been given to me by my regional rep is different from what has come here because of the transmission. But without that, you are actually not a person of superior knowledge than those who are actually on the ground. So elections are actually won at the polling station and at the collation level. That's where tallying is just done. So what tallying, unless there's an error in it, you can never override what has happened at the polling station. That is actually the lesson in it.
But so this is something that we're establishing today because, you know, it could play out the other way. You could be on the other side next time. So is that what we are establishing really, that the strong room is just endorsing what has been done on the ground?
Well, the strong room is actually supposed to check, cross-check. It's supposed to be a due diligence room. But it's different from the primary counting level, where the real counting and recording takes place. So if the due diligence work is not based on you having the real ballot paper, it means that you cannot have superior knowledge. That's why we have primary, we have secondary, and then we have tertiary. In this case, there's even a fourth leg that the Electoral Commission explained in their response, that whatever is happening at the primary level is the most crucial level. In fact, when we were even schooling, at the primary level, if you don't get your foundation right, anything you build on it will become a very difficult enterprise to engage in. So that is where all political parties have to pay enough attention to and make sure that the counting is properly recorded. As soon as it's coming up, it's about tallying. And if you have your papers in terms of your pink sheet, it's about tallying. So they should have just come to tell us in Ashanti region that we are saying that it was padded by 390-something thousand votes. It turned out that there was no evidence. And in fact, the original reps from constituencies, polling stations, and then regional levels are all signed. So it means that they were just making a story up to more or less antagonize a region that they felt they were not going to get a lot of votes from.
Dr. Poku-Edusei, are you concerned that an agent was deceived, allegedly? You are a party in future elections. Is this a concern to you, or you're looking at it strictly? Well, it is none of your business because you didn't fall for that.
Genuinely, you will not expect any person to be deceived by any public officer. But now, Mama B, I can vouch that this claim of deceit, first of all, was not actually pleaded, because when you plead matters of deceit, fraud, and defrauding, those matters border on criminality. So what will happen is that you have to then give particulars. So you have to flesh it out that this is what happened before you can lay claim to issues of deceit. Without that kind of pleading, you can't even lead evidence on it, and therefore claims of defeat is an afterthought. It is an afterthought claim by the witness for the petitioner to be able to put their case across. But the standard will be at a level of criminality, and that is beyond reasonable doubt. They will not be able to establish that. And I'm telling you, that will fall flat when it comes to addressing the courts on it.
Okay, so I was hoping that we could have an administrative understanding of this instead of the legal approach. I appreciate that. But isn't there, as stakeholders, and there conversations like that, off-record conversations that are not strictly according to the book?
Mama, you know what happened? The first question that the lead lawyer for the second respondent, Mr. Kutuampa, asked Michael Pesahwai. He said, I put it to you that the chairperson of the Electoral Commission has no right to instruct you to, as it were, go out of the room. Is it correct? He said, yes, it is true. So it tells you, and then later on, as I said, instructed to then turn out to be instructed through a colleague, which is not the same. Because when stories are coming up, you are being told, as Mr. Adaudu said, it means that he was informed. So that's where the gunman situation can never be proven when you are taking your narrative from a colleague. Because you will not be under that command. It's more or less going to be an information if it has even happened, and I'm not saying it did, that Mr. Roger Metonunu will give to Dr. Pesahwai, that I've been told by the EC chair that you should go and talk to our presidential candidate. One person could have gone, the message could have been conveyed, and I don't know the gravity of the message that he felt that it was so loaded that both of them had to leave and more or less be derelict in the discharge of their duty.
All right.
That's why one of the judges said they didn't take their training seriously.
Okay, on that note, let me bring in Mr. Kojoga Daudu. And again, the bench came in with their questions. Justice Appel, just as he delivered his earlier 3 questions to the first witness, he came in again commenting and asking basically why 2 agents had to leave at the same time to convey a message. Ordinary people are interpreting this, they are listening to it, and it doesn't sound convincing that 2 agents of the candidates in a place where they are needed. I mean, there's a purpose for which they put both of them there. And they're asking, why couldn't one person do it? Do you regret now putting forward this witness? And do you regret that this bit of the testimony came out?
No, not at all. Not at all. Not at all. We are clear in our mind as to what happened. And we are clear in our mind that they work as a team, and as a team, they decided to go and inform the president because the nature of the work they were involved in. One person was working on the S, some person was engaging the.
Well, I have to apologize. The connection is going terribly bad there. We can hardly hear you, Mr. Kojoga Daudu. We'll try another means and see if we can have you make your points. Kojoga Daudu is a lawyer. He's a member of the NDC's legal team. Also on this conversation is Dr. Poku Edusei, who is also a lawyer and member of the NPP's communications team. Mr. Daudu, let's try again. You were making the point justifying why it makes sense that the 2 agents left to communicate something to the presidential candidate then.
Yes, because of the roles that they were playing over there. So I don't see anything wrong with it, and it's because they acted in good faith. If they suspected that they were going to do something contrary behind them, they would not have done that. And you see, we have seen it all over, that the EC tells you one thing during this election. The same thing happened in Sefri also when they said there was instruction from the chairperson that they should suspend because they were issued with 1 ballot. They suspended it. Only the next day they said they should come for resolution. They went the resolution. They brought in the military and the police, and results were declared in Sefri also. It's the same thing that happened in Tetima, Zabzugu. So this is a trend that this was employed. So I don't have a problem with that. Now you ask a question whether some lessons have been learned from the 2013 petition. Now, you see, they are still saying that being an agent at the National Coalition Center is more like a glorified observer. That is not so. And he came back to the point that it's for due diligence. So I asked that if the figures, an example is every polling station should not have more than maybe 700 people voting. Now, if you come to see that the results that was sent in is about 1,300, and you go and calculate and you realize that these are the figures, you look at the list, people who voted, can't you do due diligence and say that there is an error here, there's something wrong? The fact that it's been signed doesn't mean that you cannot do diligence and bring it to the attention and say that this is the total number of voters and the votes we have here is about 50% plus. It happened in this election. We saw it. Now, when the impression I get, the questions that are being asked, the impression I get is that you are saying that, yes, you were performing a duty for and on behalf of the person. So when you come, you don't need to engage or take instruction from the Electoral Commission. It means that going forward, nobody is going to take instruction from the Electoral Commission. Nobody is, for what they are going to do, it means that we are going to insist, and there's not going to be an engagement. Especially there's not going to be an engagement with the stakeholders, because we will insist on what the law says and has to be done. And going forward, it means that it is going to be difficult because stakeholders were there. And now if the court is saying that there was dereliction of duty by engaging and also collaborating to see how issues can be done, resolved based on precedents, what was done in 2008 and 2012, you are saying that it is based on that. It means that in future, nobody's going to see eye to eye with the Electoral Commission, and it will insist on every bit. And that is when they will come and say that somebody is being difficult and should be removed from the collation center or anything. And that is recipe for chaos. So we should be careful when we are saying that you don't have to take instruction from Electoral Commission. It means that when we are going, we will be armed to the teeth with our law, we'll be armed to the teeth with procedure, and say that this is what has to be done, and we are not going to agree to anything Electoral Commission would say. So what would be the chaos from the polling station coming to collation center? There were issues that happened at polling stations, and presiding officers and all the parties had to agree that let's bring it to the collation center.
Okay,
let's bring it to collation center for resolution.
I want to ask you both.
Or we bring in the. Yes, you can go ahead.
Yes, I want to ask you both a question. Even though it's coming out of this case, I want you to address it as individual lawyers because it could happen to you someday. Another question or a follow-up of Justice Apau's question, where he sort of makes, and I don't know whether to say judgment or he takes a certain position. And I just want to read exactly what he said. Then you see, would it be right for me to say that by taking contrary instructions from the chairperson of the first respondent, granted what you're saying is true, you did not help the cause of the petitioner who sent you there? Is this a comment that you appreciate as lawyers if you were in courts and even before judgment is delivered, a judge said this about your case? Dr. Pokoduse.
Well, this particular comment was not allowed in because an objection was raised by Mr. Chikata that amounts to harassment, and the judge eventually left it, even though the use of the word harassment didn't sit well with the judge. So it wouldn't go in. But if you look at Section 68 of our Evidence Act, it says that when the court on its own can even ask a person to come and be a witness, or when parties bring their witness after they have finished with the examination in chief and the cross-examination, the judge can also ask his own questions. So they are allowed to ask questions, of course. Yeah. It's not normally supposed to be judgmental, but what Mr. Apple was saying was that this is an inference I'm getting from what you have said. and eventually it wasn't entered. But it tells you what is actually going through their mind at that particular point in time.
Okay, so you would appreciate that as a lawyer in a case, and you wouldn't take offense?
Well, you then know that what is going on in court, if these inferences are being drawn and these kinds of thoughts are going through the minds of the adjudicators, it tells you that you then have to up your game. Otherwise, some deductions and inferences and conclusions could be reached against you at the end of the day.
Let me ask my question again. Would you have objected just like Chachu did?
Oh, yes. I mean, it was within the province of Mr. Chikata to object that inference will be it's an overstretch. And at that point, because the witness had answered that he believed in the good faith, as he said. But as for that faith, it's always said, but it's always in the bosom of the one who claims that he had good faith. And that cannot be seen in the face. Okay.
Mr. Daudu, I asked this question, I put it to you as lawyers, so I want you to address it as such.
I am their lawyer. Please, I need an extract.
Hello, Mr. Kojoga Daudu.
Hello?
Yes, Mr. Daudu.
Okay.
Mr. Daudu, yes, Mr. Daudu, you're on air. The question I asked...
Hello?
Hello, Mr. Daudu, I can hear you. Can you hear me, please?
Hello?
Okay, we seem to have... we're having an issue there. Mr. Kojoga Daudu, I'm trying again. Can you hear me, please? Okay, I'm afraid we've lost him. But joining us is Justice Abdullahi. He's a law lecturer, the UPSA School of Law. Mr. Abdullahi, very good morning to you. Thank you for your time. Hello, Justice Abdullahi.
Hello.
Good morning, Mama V.
Okay, good morning. Thanks for joining us. Mr. Daudu, I see you are back with us. Can you hear me now, please? Mr. Daudu, can you hear me?
Hello.
Hello, Mr. Daudu, can you hear me? Okay, I'm afraid Mr. Daudu cannot hear me, which means we'll have to work on that.
I can hear you now. Okay. I can hear you.
Okay, Mr. Daudu, so
I can hear you, Mama.
Okay, great. Can you begin to address the issue that I put on the table to you as legal practitioners?
Yes, I think that, yes, the judges are allowed to also ask questions. But when, at the same time, judges also are not allowed to set up a case for any party. So I think that where the bench was being judgmental as to what has to be done, that is where the issue was raised, that the client, the witness was being harassed. You see, as a judge, if you have any comment or anything, that's why some of them will prefer that they will say it in their judgment. They remain silent. You are the referee, you are the arbiter. So you need not to ask questions or do things that will be obvious or appear to the other side that you are doing the case for one of the parties or you are doing investigation on behalf of society. I don't think that that is it. So judges are allowed, or the bench is allowed to ask questions because the purpose is for clarity and also understand the issues. But when you cross the limit where it's been seen that you are trying to do the case or questions that had to be put by one party was not put and you are putting it, I think that it then becomes judgmental and obvious that you are not sitting in as an umpire to decide the matter. And it is always better. That's why some judges will remain quiet and the law is in their bosom. And when their judgment, they would make their comment, they would say their observation in the judgment.
Okay. Justice Abdullahi, I think you joined us at a point where my guests, the two other lawyers, were talking about the Evidence Act, particularly Section 68. So I guess it's been established now that the judges can ask questions, but we're talking specifically about Justice Apo's question and the comments that he made, saying that the witness did not take his job seriously. He did not help the petitioner. where a point of objection was raised by the witness's lawyer. I'm asking, as a lawyer, would you take offense to these comments?
Indeed, Mama V, if you remember yesterday, I had indicated that it is indeed within the right of the bench to probe further if they wish to do so. Of course, there's a limit. There has to be a balancing act between being seen to be doing the case for one side and also just an attempt to understand the issues. Now, that said, if the kind of commentary that were made, that are made, are such that they are not really probing further, they are not probing or asking for clarification, but rather come in the form of attacks or in this case, labeling of a particular witness, as we saw with Justice Apau, who is one of my respected justices. Indeed, it's quite worrying. But it's worrying to the extent that these were not questions; these were labels and remarks that could have been made in the judgment of Justice Apau if and when he decides to write his judgment. I do not think. I think maybe the circumstances of yesterday probably led to that kind of commentary, but that is not his style. As I've known, this is not his style. He doesn't come across to me as the kind of person who would venture into the arena of litigation and be making such comments. Asking the question was appropriate; it was right, but going beyond the question and almost attacking the witness by labeling him as having derelict on his duty and among other comments, I do not think that one was appropriate. I think going forward, I'm not sure we would see that because, like I've said, this is not Justice Apau that I know, and so maybe we should accept that. Few times you all get it wrong, and this is one of such few times that he went beyond what he would ordinarily do.
Okay. Well, I appreciate that, Justice Abdullahi, except that the tone has been set. We've seen, very powerful questions being put to the two witnesses, at least by the bench. And I guess going forward with the other witnesses that will appear, people will have same expectations. Remember that this is being broadcast across the world, and what the people think will also be important.
Mama V, I think having expectations of things to be done or questions to be asked would be a wrong expectation to have. And this is because every witness comes with his own peculiarities and other idiosyncrasies. So you should understand that it is only when it becomes material to the bench for them to ask questions that they will ask those questions. If not material, or if the appropriate questions have been asked, or if the understanding is clear, you do not expect that simply because I asked a witness A question, I must also ask witness B question, even when it is not necessary. And that is not the job of the bench, and that is not what we should expect.
Okay. All right.
And yeah.
Okay.
Basically.
Okay, great. So back to the three of you on this issue of where we are today. Inspection of documents, and again, you're all lawyers. These are things that you would do that would not require, a party filing and asking the court to get the other party to allow it to inspect documents. That's the process that's been filed by the petitioner in this case. Is there some bad faith, Dr. Poku, to say, why have we gotten to this point?
Well, there's no bad faith in that the rules permit generally, and I'm talking in this case the rules, I'm talking of the High Court rules, DI 47, for you to ask for discoveries. So it can be interrogatories, it can be requests for documents, and that kind of thing. But in this case, there's precedent to it. In 2013, the then petitioners requested for the original copies of the pink sheet from the Electoral Commission. And it was opposed to by the then respondent, and the tables tend to have turned a bit. In this case, the then petitioners have become second respondents, and the EC is the same. And then the petitioner, who was then the respondent, is now the petitioner. So there are indications from us that we are vehemently opposed to the request.
But this is something that you also wanted in the last petition, except that because you find yourself on the other side, you're opposing, you're objecting.
Wasn't granted. And the decision, the ruling that was given by the court is reported in the Supreme Court of Ghana Law Report. There's sense in it, in the sense that when we were going through the arrangements for the election, we made it a point that at every stage, documents are supposed to be shared. So unless you are able to say that you were not given a counterfoil copy or a carbon copy of the document, it means that if you were given, then you will not be entitled to get the original again, because that will be duplicitous. It will be irrelevant, because what is on the original is translated onto the carbon copies that you were given. So you have to then show us that this original that was given to us, or was not given to us, or when it was given to us, there was nothing recorded on it. Other than that, they will have a tall order in convincing them why the copies will not be enough in this case. Okay. And I think that the copies should be enough. All right.
Kojoga Daudu, based on precedents, this is, I don't know how this is going to go for you. Hello, Mr. Daudu? Do I still have Kojoga Daudu?
Yes, I'm here. Can you hear me now?
All right, yes, I can hear you. I was just, saying that based on precedents, you should know where this is going.
No, not at all. You see, when the court is always making a decision, it's based on the facts, it's based on the circumstance, and it's based on what is happening. So they asked, in the 2013 petition, they asked that they wanted copies of the document. And the court, the carbon copy had been given to OT. So if the documents are public documents have been given, then you cannot the same document because you've been given copy. What we ask in the court is to inspect the final document. Remember that when they sign at the constituency collation, it is sent to the regional collation, and the regional collation officer would either fax or send it to the chairperson. Now, in what mode it was transferred, we have it, and we want to see that those figures that was transferred, is it the same? And we have given example that when you go to Eastern region, what was signed by the agents and the regional collation at the regional collation, it seems to be different from what was sent to Accra. So we are asking that we want to inspect the original document and compare and see that it's the same figure. And I'm sure we were asking that what was the mode by which it was brought? Was it fax? Was it so that we can see that, because it tells us that we are looking at it, and when we look at what we have, the documents we have, we think that there has been something wrong, maybe in the mode of when it was being sent or it was sent to, so that we want to see that what is the original copy, and we will inspect it. I think that there are two different situations, and the court will look at it carefully and say that, yes, we will grant you or we may not grant you.
All right.
Remember, we have We have asked them some questions to admit. They have refused, and that is the basis. We are saying that we have asked them. The law asks that we ask them. If they refuse, we are now asking the court to compel them so that we can inspect it.
Okay. Fortunately, we'll know that decision in less than 2 hours. We want to wrap this up. Justice Abdullahi, yesterday you predicted that it was going to be a bit boring, but it was far from boring. It was too exciting. What do you foresee today? Do you regret telling me that yesterday?
Also, Mamami, yesterday I also predicted that it was going to be very short.
Yeah.
And maximum 3 hours. And indeed, that is exactly what happened. I think we should also put that one across. That
yes, sir.
By time.
So that's 1-1.
So, well, I wouldn't call it 1-1. I think it's still 2-0. So really, today, indeed, we are going to have the application being heard. I do not foresee a lengthy argument being made on this, despite the fact that there are precedents and all of that. I do expect a snappy decision on this one. In fact, I also expect that today the Electoral Commission be put in the box. And I say this because of several factors. First, because time is of the essence. We've already spent 4 days out of the 6, and so we barely have 2. And we have 2 other witnesses. And considering the fact that the John Mahama team has indicated via decision, more or less, to invite yet another witness, should this application be granted, I can clearly confirm, as I have been telling you every day, that we are likely to have an extended time of the 42 days that the rules have set for us to do this whole exercise.
All right.
Should the Electoral Commission man box today, clearly today will be more excited because the whole suit is surrounded on her evidence. The whole suit. And so we should expect more probing questions from Tashishi Kata, and that's clearly a proceeding that I would not want anyone to miss.
Okay. Well,
I expect everybody to be ready for the cross-examination of Tashishi Kata on the Electoral Commission. I do not expect anything from the Electoral Commission because the two have the same.
Oh, okay. I think that connection has gone bad, but really, this is where we have to end this one. Dr. Pokwuedu say, we wish your team the very best. Kojoga Daudu, we wish your team the very best as well. We hope that it will be another exciting election petition hearing today.